of the day. I am really pleased that we have three very distinguished scholars and two of my very close friends as commentators. So I think that while we started off very strong, as all good trial lawyers know, you have to be able to end with a bang as well. So I think that this last panel will do just that. To my immediate left is Bob Mosteller. He's a professor of law at the University of North Carolina with Rich Rosen. They're kind of a package deal, I think. They started together at the Public Defender's Service, and they've ended up at North Carolina, and who knows where they'll go from there. But Bob was the training director at PDS and worked with Barb Bergman when she was a young lawyer there. So he did an excellent job training her. He's written a lot. I'd say for all three of these gentlemen to my left, they are all prodigious scholars, have written a lot, and have written extremely good articles on the criminal justice system. Next to Bob is Darrell Brown. Darrell is a law professor at the University of Virginia School of Law. In addition to his, the number of scholarly articles he's written, Darrell also brings a public defender background to this conference, like many people. So we're delighted to have Darrell join us as well. Last but certainly not least is Wayne Logan. Wayne is one of the few people who is not a public defender, but Wayne actually went to the University of Wisconsin, so he's a Badger, and that obviously is part of the reason he was invited here. But he also was the research assistant with my mentor at the University of Wisconsin, Frank Remington, who was one of the leading criminal justice scholars in the country. So both Wayne and I had the opportunity to work with Frank. And he has obviously done very well for himself since graduating from the University of Wisconsin. To my far right, and in many respects he's to the far right of me, is my good friend Roscoe Howard. Roscoe is now with his, this is about your 8th law firm in the last 2 years. Andrews Kurth. It's an excellent law firm. Roscoe has now moved from being Roscoe was a law professor at the University of Kansas. Need I say more? Okay, no. Roscoe also was with the Justice Department for many years. Roscoe was an independent counsel and did some very high-profile prosecutions as an independent counsel. Roscoe was appointed by President Bush to be the U.S. Attorney for D.C., so he bumped heads with a lot of the public defenders from the D.C. Public Defender's Office. So Roscoe brings a very distinguished and very interesting perspective to this panel. And last, but certainly not least, is my very dear friend Barb Bergman, who is the Associate Dean at the University of New Mexico School of Law. Barb, I could talk for a long time about Barb. She was the past president of the National Association of Criminal Defense Lawyers. She was the amicus chair for years for that organization. She has taught all over the country trial advocacy, and she was my teammate on the Nichols defense team, and we spent a lot of time for 4.5 years when we worked on that case. So I think this will be an excellent panel, and I will now sit down.
Thank you, Rod. Again, I'm Bob Mosteller, and I had the great fortune in September of 1976 to start at the Public Defender Service, and in that group was Steve Wright and Rich Rosen. And before I went there, I talked to Norm Weststein, who had left at that point. Norm is apparently incredibly old, I hear. And he assured me that it was a good place to work, and he was absolutely correct. Barbara Bergman came later, and we became fast friends. why did I do this? Because I had a dream, and I don't have anything, a real reason about why it was. I grew up in the middle of nowhere in North Carolina, a Red Clay hillside farm. My parents were a school teacher and a mail carrier. The first lawyer I knew about and met was Perry Mason on TV, and for a long time after that, until roughly I was a senior in high school, that I'd never met a real lawyer. And I never outgrew Perry Mason. I mean, the part of it is that life ought to be fun, that you ought to do something that mattered to you, and somewhere in this idea there was something about equality that came out of the basic values that my family instilled in me, just something about there ought to be fairness, and that some of us who were really good, kick-ass good, ought to want to work for people who had no money, and to basically try to give them justice, and to care about it, And I stayed at Public Defender for 7 years. It's the institution I'm proudest of being a part of. You know, to this day, I'm just delighted that I was part of that group, and fortunately it has continued with a good group of people coming in and giving their heart and soul to it. And public defenders all over the country are the same sorts of people, you know, the same sorts of people that go into it. That if you do public defender work and are good and work hard at it, you will do better for your clients than they would have had otherwise. The thing I didn't want to talk about was how to work within a system that didn't allow you to practice good law, because I don't know anything about that. I had the good fortune of working in a system that let me be a good lawyer, and in fact told me that if I didn't practice good law, I needed to not handle my cases. And that just, you know, this thing about backing you up, it wasn't backing you up. It was that if you're not practicing good law, you shouldn't be picking up the cases. And it's a wonderful situation to be in, because it puts the whole onus on you. You can never say, I didn't do it well because I didn't have time. No, you didn't do it well because you didn't do it well. You know, that you're supposed to win this case, and you're supposed to win it because you're good and your client deserves it. Now, what was that? That's a dream for a lot of people, and so I'm not trying to tell you that living in that world is a luxury that everybody can afford, but that's what we ought to aspire to. You know, that's what we ought to aspire to. And I wanted to pick up something, and Rich and I, for 26 years, I was at Duke, and, you know, basketball is a big part of me. I've always been light blue in my color. I went to UNC undergraduate, and so I was among the enemy for 26 years. And so, and now I've come home, and I'll come back to basketball later on. But, and so I learned in that period of time living with adversity. But I also really enjoyed coming to Carolina for another reason. Rich is a fabulous colleague to have in the sense of having really good ideas, and I've learned a lot from him. And one of the things I've learned is innocence, and to talk about innocence. Because when I was a public defender, and I still have some problems with this, when I was a public defender, talking about innocence was not something I felt comfortable with. And I still think it's a tough thing to do for the line attorney, but I think it is part of what we need to do in order to help to get to a better system, and that's to latch on to, and it's as best I can tell, the only thing the public will care about with respect to criminal justice. It's incredibly empowering. It's an enabler. It is the public's desire to protect the innocent. The public's desire to protect the innocent. And my argument is, and it's one that I think has to be harnessed, is that good indigent defense is a part of protecting the innocent. Is a part of protecting the innocent, and we got to work that through, because every now and then they'll tell you, surely you're making this up, or surely this is wrong. And it's partially that we don't know who's innocent, and I want to work that through. But, and so Janet Reno, when she was Attorney General, said, in the end, a good lawyer is the best defense against wrongful conviction. And I want to repeat that. In the end, a good lawyer is the best defense against wrongful conviction. And so I think there's a truth in there. There's a truth in there. The assumption among critics is that defense work is not about innocence and it's not about accuracy. I think the latter is largely true. The former is not. And what do I mean by the latter is largely true. If we do our job as public defenders, we'll get more guilty people off. And so that when people are talking about accuracy, part of it is that you have false positives and you have false negatives. You know, if you do good indigent defense work, some guilty people will be acquitted. But it is about innocence. It is about innocence. And in America, and I think it's still true, we don't respond to our better angels today, but I still think that something along the lines of it's better that 10 guilty people, in order to make sure that one innocent person is not convicted, it is better to let 10 guilty people go free. And you know, over time, people have talked about it as 100 to 1 or bigger, and some people that are conservatives say it ought to be closer to 50-50 or 1 to 5. But I still think we care more about innocence than we care about the other errors in the system, and we need to. And that's the thing to harness. That's the thing to harness. And so, at least one of the arguments coming back is, well, surely you know who is innocent among your clients. Surely at least the defense attorneys know. Surely you can pick it out. And one of the dangers of this argument is if you can draw the distinctions, you may get your funding cut even more. Because if they can cut them for the guilty people, then they'll be tempted to do that. But my argument is that, and it's really true, we don't know. The defense people don't know. It's almost impossible to sort them out among the people that matter. And that's an important part of this, that the innocent hide among the guilty. The innocent hide among the reasonable doubt cases. And why is it true that you don't represent very many innocent people? Unless you have a rogue prosecutor like Mike Knopf on the Duke lacrosse case. You flush those cases on the prosecution side. The people that are clearly innocent are not in the system. The people that are clearly innocent are not in the system if it's demonstratively innocent, unless you have someone who's framing someone, unless you have a bad prosecutor, a bad somebody in the police department. The clearly innocent people are out of there. They're not in the system. And as you work it on through, the ones that are a little bit more, you'll get a few more dismissed. And then as we move along, we are largely trying the cases among the guilty. And so that those of us who do the defense work know that. And in fact, it's something of a defense mechanism for those that are defense attorneys. And they sometimes say that defense attorneys really want to get guilty people off, but they really don't care that much about getting innocent people off. Well, it's kind of backwards. That if you have an innocent person, if you actually believe it's an innocent person, you can't go to sleep. There is nothing that can go right in that case because the only outcome is for that person to be acquitted. And if you can't get that person acquitted, you ought to hang it up. Or, it's just an incredible burden. It's hard to, when you actually believe that, it's hard to be able to come to terms with it. So to some degree, defense attorneys, it's better to believe that your clients are guilty because then you are doing good work. They might be innocent, but you don't know it. And so you work along that way. There's another part of it is why you can't really care about it as a line defender. If the only thing you live for is to represent innocent people, most days will be duds. I mean, you're going in there and, how many did you see that were innocent today? How many people did you help that day that were innocent? I mean, the way we survive as public defenders, and if this isn't part of what you are, you can't do it. It is you help people. That when a person comes in the door, they are in terrible need. And defendants are human beings. For people who are never representing defendants, they are way more like you and me than the public imagines. That these are human beings in need, and the triage I think we all do is trying to pick out within our busy days how to allocate our time to help the most people the most. There's various different ways to do it. And for some people it will be sentencing work. For some people it will be motions to suppress. For some people it will be doing trials. And in some situations it's trying hopeless cases because there's nothing else to do. and that basically that case needs to be tried because it just has to be tried. And you're doing lots of different things, and so it is very tough for the line person to talk and think about this. And at least I'll come around. Whether or not it is tough for the people who are trying to get the funding, the kind of thing that Rich was talking about, I think it shouldn't be. I think it shouldn't be that talking the talk, being able to make this argument, being able to make this argument for two reasons is important. First, it's true. And second, it is effective, I think. I think it is one of the few things that people respond to today. I'm not sure about that, but I think that in a world in which we have lots of other competing interests in which budgets are tight, and if you're giving it to public defenders, you're going to be taking it from schools or roads or something like that. It needs to also, in addition, I think, in addition to responding to a constitutional argument, it needs to respond to an argument that has public appeal. When I was a public defender, my attitude, and still is, was something but I didn't worry about it that much on a day-by-day basis. And I, in some ways, didn't have to worry about it that much on a day-by-day basis. I represented mostly serious cases in the public defender in D.C., a lot of murders and serious assaults. And it may happen to folks that are out there differently, but my clients all said they were innocent. I mean, so it wasn't as if people were coming in and they were telling me they were guilty. You know, the evidence might suggest they were guilty, but they told me they were innocent. And I didn't really work hard at finding out a contrary story for a while. We'd often get to a situation where plea was what we needed to do. But they kept telling me they were innocent, and I would talk to my supervisor and said, why is that? Why is that? I didn't tell him it mattered to me. And he said, it may not matter to you, but to most defendants, they don't believe that. They believe that unless their lawyer thinks they're innocent, the lawyer really won't work for them. And I think that's one reason that defendants don't easily say that they're guilty, because they think that we, on the other side, are motivated for having this as pushing our buttons. And so that lawyers, I think, start developing this idea that most of the people, defense attorneys, most of the people that come in are guilty, and that we're sorting between cases that are guilty. We care intensely about our clients, but I don't think we focus enough on the possibility of innocence. And I want to talk about a couple innocence cases, and one of the things I want to talk about at the end is how can we develop stories. Okay, now, I had a case, and it's hard to call these party favorites, but I've got an article that if anybody would want to, it's titled, Why Defense Attorneys Cannot But Do Care About Innocence. And so that it's published in Santa Clara, and so there are copies up here if people would like to have them after my talk. But I set out some stories in there, and I'll have a couple more in the article that'll be coming out in this law review. And one of the stories I wanted to focus on is I think probably typical, but we don't know because it's an innocence fluke. And most innocence cases are flukes. Most of those are flukes in some ways. The DNA cases are all in some ways flukes. That they were tried under one system, and then a new technology came to let us know that these were mistakes. They were mistakes. A whole group of flukes. And the thing that's most common about them, the really central feature, is all these people were innocent. It's not clear that they're joined together in really systematic ways. Other than that, it's just that there was DNA in the end that proved they were innocent. And this was a case of proof of innocence through a fluke, but a typical case that I think is scary in lots of ways, because my guess is it happens a lot. It's an armed robbery case. There weren't any proceeds. There wasn't any blood. There's not any DNA left over. It's not a one-witness ID case. It's a three-witness ID case. They ID'd my client. He lived in the neighborhood where it happened. He had a criminal record that fit the kind of crime. There wasn't any reason to believe that he was innocent. But it turns out through a fluke we found out he's innocent. Now, how does this happen? Well, the prosecutor call the witnesses to the grand jury. There were 3 witnesses, and they came in individually, and they each told him, you have the wrong guy. You have the wrong guy, each individually. And what did they say? The right guy is sitting out in your witness room. But as they came in that day, each of them saw the person who did it. And it was a person, as is often the case in big cities, defendants, victims, witnesses play different roles at different times, and this person was a witness or a victim in another criminal case sitting out in the waiting room of the U.S. Attorney's Office in Washington, D.C. Each of them comes in independently and says, he's out there, and they later arrest that guy and they prosecute them. So they call me up, and this case is gone. And, you say, of course, you knew he was innocent, right? Ha. There's no way I had thought he was anything different than anybody else, because when he comes in, he fits the profile. He's got these various convictions, and the kind of things that tell people that a person's guilty, I was starting to get, because they've given me a defense. And I start checking it out. And I won't go into the detail of it, but I started checking it out, and it doesn't work out. What he's telling me is not the truth. And, that's one of the things that lets you know that your client's guilty. When the story they give you is not the truth. It's not the truth. And I haven't gone back to defense B yet. But, by the time you get into defense B, it's along the lines of, be serious, Mosteller. This guy's not innocent if we're working on plan B as far as it. And where's my proof ever going to be in this case? My proof is never going to exist in this case that this guy is innocent, had it not been for that fluke. There wasn't going to be any DNA. There's not probably going to be enough pressure on the prosecutor to worry about snitches and things like that. It could be that sometime in the future somebody will say that they did it instead of this guy. But it's not likely to happen. This is a person that could have gone to jail for a long time. This is the kind of person that I would have tried to talk into a plea not long from now. And I don't know how many people that I talked into pleas. And I still don't think it's necessarily wrong, because it's not a good idea to spend 15 years in prison for a crime you didn't do when you can spend 5 years in prison for a crime you didn't do. That you need actually to make a good judgment about. So I don't regret if I did, and I don't know whether I did it. If I talked some people into taking pleas that made sense and they were innocent, I still don't regret it. If it was the right thing to do in terms of how many days in prison they were going to serve, it's something along the lines of, it doesn't help you anymore when I would talk to people, if you're spending this extra time in prison, whether or not you're innocent or guilty, that you're looking at. But that I think is the reality of a lot of cases. And I don't know how many there were of cases like this, but I think there are more than I want to believe. One of the reasons that I think that is, our little bit of data with respect to DNA, and they look in the Justice Department, about a quarter of identification cases where they check out DNA and they've done an arrest are innocent people. About a quarter of the people who are arrested in these ID cases where they have DNA were innocent. About a quarter of their initial arrest. Now, how many of those people went very far in the system? I don't know. My client, the person like this person, the person who is not pure as the driven snow, is more likely to be carried further through the system. And when does the defense attorney know whether they're innocent? It's a bigger problem than I think we often think about, and it's harder to find the flukes. Now, what's the answer I'm trying to give you? I think we need to start to be able to tell this story better. And part of it is that when I started thinking about my practice, in part thanks to Rich, it was dredging up, thinking about these stories. I hadn't thought about these stories, and so I have 3, 4, 5, 6 that are worth telling. Within an office, and if you work at it, how many do you have? I don't know whether there are very many, but within Missouri, within big public defender offices, how many can you bring together? How many different places can you talk about where we found that a person was innocent, that we did good work for? Like murder on Sunday morning, where you can show that because you did good lawyering, you got an acquittal for someone who you can show was not only acquitted, but was innocent from good work. How many fluke exonerations are there? How many different people can you start bringing, like Rich was talking about, to meetings in which good defense work helped to help the innocent, to talk about this. And I don't know whether it's going to all work out, because when to some degree playing with fire, it can be turned against you if the only thing that we're involved in is innocent work. But the thing I want to have people start thinking about is, can we do a better job of talking about what it is that we actually do? And this is my basketball reference I want to come back to. If you are a Carolina fan, as I am, you either need to think about basketball in the past or hopefully in the future. You do not think about it. You do not think about it in the present. You do not think about it in the present. So I'll get to the past in just a minute. But the talk that would sometimes go between Duke and Carolina folks is, sure, you can talk the talk, but can you walk the walk? Sure, you can say you can play game, but do you have game? Do you have game? Now, I think that I can talk about the past in which we could talk properly. And one of the good things is I'm in Missouri. And not long ago, a little bit less than a year ago, I was in Detroit. And I was watching a Tar Heel, who I now understand is from the Boot Heel. And it was Tyler Hansbrough. Tyler Hansbrough, a great citizen of this state, and a wonderful Tar Heel, led us to victory in the Final Four. And so at that time we could talk. And what's the whole? How do I bring all this together? Public defenders already walk the walk. We actually already do innocence work. We have the goods. I think what we need to start learning how to do is to talk the talk. From the point of view of having effective stories that can be used to help energize a public that isn't necessarily responding to our better angels at this point, but a public that I think does still care about innocence. And it's something that I haven't thought about for all that long. Rich got me into thinking about, and I think it's worth exploring, because as a community, I think we have something here that is both true and powerful. So, thanks.
Good afternoon. Thank you for still being here and being awake. If you're like me, I'm a former public defender, like many here, or present public defenders, or former public defenders. I'm one of the few up here who did not work at PDS, but I worked at a very good public defender office at the time in Clark County, Georgia, which is where the University of Georgia is. And the University of Georgia Law School had the contract to be the public defender office in Athens. And I didn't realize at the time what a good experience it was, or how good I had it, I guess, in comparison to other places. I was in a fairly small Georgia town. It's not the profile of a place you think is a model of public defense. And maybe it's no PBS, but it was for a long time a darn shot better than the Georgia standard, and better than a lot of people have it. I'll just in response to Bob's talk, I'll tell you my one only sort of anecdote / innocent story, which is the last case I really handled as a public defender in Athens, Georgia. I lost, at least initially, and it was one of those rare cases where I was just absolutely convinced that my client was innocent, and it was in part because it was an undercover drug sting, and I had filmed the drug dealer from the hidden camera in the car selling the drugs, and he just didn't look like my client. It just wasn't the guy. And I went and talked to a bunch of his friends, and they all said, no, that's so and so, that's somebody else, and it was just clear it wasn't my guy. And so we went to the bench trial, and I just was fairly confident we were going to win, and we didn't win. The judge looked at the tape, looked at my client, and just didn't win, and I was stunned. And so one of my last acts as a public defender was to file an effective assistance of counsel on myself had to get this guy a new proceeding somehow. I didn't realize, I don't think I knew Strickland Docket well enough at the time to know that since I was awake and sober, I was going to be. But luckily it was responsible enough, I guess in the end, district attorney office that, you know, it's a small town, there's 8 or 10 of them, 8 or 10 of us, and the EA called me up and said, what is this crap you just filed? I mean, we had never seen a ineffective assistance motion before. And I just said, this is the one case, I swear, I know this guy's innocent. It's just wrong. You have to undo it. He says, you know, if you're that personally convinced, you know, come talk to me in the office and we'll unpack it. And sort of long story short, the DA helped undo the case. So that, I mean, that was sort of a hopeful note on the beginning of that public defender career. But I generally approach these things, the topics of public defense and indigent defense, what I write about them in a state of despair. And coming to something like this, especially hearing the Right Reverend Stephen Bright, you can somehow find hope and motivation in all the despair and the state of affairs that we find ourselves in. So the other good news about my talk this afternoon is if the gods are merciful, this will be shorter than it would have been, because what I'm going to do is I find my papers a lot of effectively summary, or effectively pulling together things that we've talked about today. And I realize that the people, especially in this room, I don't have to convince of the problem. So part of what I was doing in this paper is sort of trying to come up with some pretty solid evidence of how disproportionate and how underfunded it is, right? So we have a lot of anecdotes and individual stories about systems being in crisis, and every system that gets studied ends up being in crisis, and we have these horror stories after horror stories and case after case. Now we can point to all these, right? But one way I've thought about looking at it sort of systemically, or sort of proving it, kind of, is to look at incarceration rates, right? What you would like to have, I guess, is caseloads and cases coming through a state system, and then measure that against public defender money. And ideally, you need some sort of baseline of what the appropriate amount of money is. Given the nature of this stuff, we just don't have that kind of baseline, right? We have what we tend to think of as an appropriate baseline, but people just disagree on it, and it's a difficult thing to figure out. But what I can show, and what we can prove sort of systemically and nationally, is that there's just no correlation with indigent defense funding and anything else that it ought to be correlated. So if you look at incarceration rates and prison populations in states, and you compare that to indigent defense funding per capita per citizen in a state, they're just all over the map. There's just no correlation. So if I had done PowerPoint, the one PowerPoint slide I would have for you would be a scatter plot graph that correlates indigent defense funding per capita with incarceration rates, and you would see there's no pattern, right? What you should have is states with lower caseloads and lower incarceration rates should have lower budgets overall, right? And as the system grows, as more cases enter the system, as more, especially when you're looking at prison, right, more felons who are getting serious time, as all that grows, right, the indigent defense system ought to grow, the indigent defense funding ought to go. And you just don't have, there's just no correlation. And so what that tells you, I think, is that it's just random, in a sense, of whether we get good public defender systems and indigent defense systems generally. And by random, I mean it's just a function of whatever happens over time in a state, right? So sometimes, and we've heard a lot today, you have some good stories, places like North Carolina, right, where things just kind of work out, where you have the right players at the right time. You can get some reform in a place that you wouldn't necessarily think would be at the top of the list, but things start working out, right? You can get a confluence of good motivated people who are organizing, and you get kind of political moment with some innocence cases, and you can get a legislature that's open to it. And so you have Wisconsin, right, which is, I now understand, a fairly good system by the standards by which we measure these things, right? And North Carolina looks pretty good, above average. If you sort of think maybe where in the abstract you would find the good systems, right? There's also no correlation there, right? You might think rich, sort of liberal states. You might think Massachusetts would have a really good indigent defense system. But no, they've had these kind of funding crises and litigation responding to the funding crisis. And then you get places like, Georgia has been mentioned as at least a little bit of progress, right? They didn't actually fund their system, but they at least got some structural improvements, right? Texas, of all places, you know, they started from a very low baseline, but it was in 2003, 2005, Republican Texas legislature, Republican governor, right? And they made some structural improvements. They've now got, whatever it is, 15 public defender offices out of 200-some counties, when they used to have next to none. And so there are little pockets of reforms you get here and there, right? But then, often in response to this kind of litigation we've heard about today, right? You've had that in 10 or 12 or more states, right? And you can often get some improvement for a few years, but then, for whatever reason, right, in that particular state, it's the next round of budget cuts or the wrong players coming to power, and indigent defense funding just ends up being extremely discretionary. Right? There's just nothing that keeps it steady, or it's very difficult to sort of align the structure and the political players in the system to keep it as a sort of steady line item. If you look at prison funding, very steady, very increasing line item over time, right? And the numbers for that are very clear, right? It's very easy to find corrections in prison budget figures for states. Harder to figure out what the indigent defense funding is, because some states have a mix of state and local, and very, very different sorts of funding mechanisms. But there's some of that data there too, and that's much more up and down, right? But, right, we know, and we've heard about today, that indigent defense is an entitlement that ought to be a mandate on the states, right? The states ought to be responding with funding to that mandate, right? And it ought to correlate with everything else in the criminal justice system. It's a mandatory piece of the criminal justice system. When caseloads increase and district attorney budgets increase and prison budgets increase, right? And courts have to expand capacity to handle more cases. You've got to expand the defense side too, right? It ought to be tracking those other components of the criminal justice system. And it's free from those other pieces, right? Which is why states can drastically cut down indigent defense and increase funding and increase capacity in the other parts of the system. In a way that just shouldn't be, right, in terms of idiot and Strickland mandates. And in a way that's just, it's hard to figure out how it, in a sense, how it occurs, right? So the part of the explanation is just everybody hates criminals. No one wants to fund indigent defense, but I think it's something more than that, because there are these good stories, right? There are these good moments where things align, and just generally, right, the way that legislatures do things, there are ways to hide the agenda. There's ways to get stuff in the budget under the radar, right? There's ways to do pork barrel, but more specifically, right? There are these moments in a lot of different states where, at least for a time, you can get indigent defense funding funded. So there's ways to overcome the political unpopularity. But it's just hard to figure out what the characteristics of the situation are and how to sort of scale that up, right? How to say, this is the way you do it. If you can get your system to look like this, then you can both make progress to increase the funding and then, more importantly, sort of stabilize it over time. So what I've sort of been thinking about, I guess, what I've begun to think about is really a lot of the ideas that we've come up with here today, or that you've heard discussed here today. And I sort of come to the conclusion of surveying those with less hope than average. I don't have Stephen Hanlon's disposition on this, but after hearing him and hearing the Reverend Wright, I do find myself momentarily, at least, hope. A little past. And so, what are the? I think first, sort of the structural challenge that makes indigent defense vulnerable, right? Is it's part of the discretionary budget of states, but it's lots of things if it's part of the discretionary budget of states, right? And they can stay relatively fixed or take only sort of reasonable and necessary hits during a recession, right? Education's pretty popular. Education also sort of resembles historically indigent defense right, in the sense of being largely local controlled, traditionally local funded, now an increasing mix of state and local funding and more state dominance of the funding. But a lot of the things where you see less variation and less feast and famine in the funding are institutions like, or budget line items like education, where there's some fixed capital cost, right? There's schools that you can't just sort of make disappear or you can let, sort of just shut down and not maintain anymore. Same thing with prisons, obviously, right? You can cut, states are now learning in this recession, right, that they can cut prison budgets a little bit, right? They can find some political will to reduce sentencing policy some. They can maybe even shut a few prisons in a few places, and they can furlough some prison workers. So there are ways to cut even those other items, right? Schools certainly take hits in hard times, but they don't. It's not as easy to cut as deeply as it is in indigent defense, which is just all staff, right? And there's nothing. There's no visible effect other than that indigent defense attorneys having much bigger caseloads or working for little or nothing when you're the appointed counsel. So there's not that sort of structural resistance to cut it, right, where you at least have this building and capital that you have to maintain. So that makes it especially vulnerable, kind of combined with the political challenge, right? And so what's the basic ways to address that, right? I think they're just the ways that we hear about here, right? They're the individual sorts of challenges that, the individual sort of litigation challenges that Steve Hammond's talked about systemically, and Wayne's going to talk about in Florida, I think, with respect to in a moment, right? There's lots of success stories, again, sort of momentary success stories, or short-term, a few years success stories coming out of that kind of litigation, right? You can think of that, I think, or we could try to creatively think of that in comparison to other sorts of systemic litigation that really changed the way legislatures had to do discretionary spending and discretionary institutions, right? And so one comparison you could think about is the really sophisticated, well-planned, years in the making trail of litigation, plan of litigation that led up to Brown v. Board, right, and the many years of litigation to sort of implement Brown v. Board's remedies for the mid-70s or so, right? So the kind of one-shot, isolated litigation that we see with some success, right, in some districts in various parts of the country now, lots of different states, right, and with mixed success, right, is one way to do it. If we could make that more systemic, right, if we could kind of come up with a global constitutional argument that would work from state to state, that would maybe be a ray of hope, right? And so you can think about whether that's possible or not. One model for that I thought Steve Hanlon might be referencing in his discussions is the kind of last couple of decades of school funding, right? So there's starting in the kind of mid-'80s or so, I think, and for a couple of decades after that, a lot of litigation in state courts under state constitutions. A lot of state constitutions have a right to education, and that was used for arguments that there should be equal funding across jurisdictions within the state, because that's how you equalize educational opportunity that the state constitution guarantees. Right? So, and that was a very kind of concerted, well-organized effort among those sorts of litigators, even though it's kind of different in every state. You're litigating under a different state constitution, there are common themes that you can kind of build on, and common interpretations of the constitutions that you can kind of convince one court after another to adopt. And that was relatively successful. It's got a lot of funding relatively more equalized within states. It shifted a lot of funding from local to state level. If the kinds of isolated district level litigation we see in indigent defense now could be transformed into that kind of impact, institution changing litigation. And that would be a way to do it, right? Another thing we've heard about are essentially sort of budget rules, right, or budget commitments. And so you have, in a few states, right, we've heard about Connecticut, I think, and I've learned today that the PDS has a version of this, and the federal defenders have a version of this, where a legislature essentially, right, the legislature is the one that passes the statute, essentially pre-commit themselves, right, or make a rule on themselves that we have to pay our public defenders the same as the district attorneys. So that's one model of legislatures sort of saying we're going to tie our own hands, right? that we're not going to get indigent defense, or at least really, I think it mostly applies to public defender offices, right, rather than the indigent defense budget as a whole. We're not going to let that get too out of line, right? Whatever the story is in those states and those jurisdictions where that kind of move happens, right, where you can convince a legislature to make that kind of parity commitment, that's a model, right, that could be a piece of the remedy puzzle. More ideally, right, you'd like the whole indigent budget to be a proportionate piece of the criminal justice system budget, right? So as prison budgets increase and court and district attorney budgets increase, indigent defense would be tracked to that somehow, right? District attorneys, of course, I mean, they complain about their own resources too, and they don't, you know, they mostly don't have ample resources. They just look good to us, you know, from our side, from our side of the bench or the courtroom. But it's not a paradise for them, right? But they can control their own caseloads, right? They have prosecutorial discretion, right? So when they hit resource constraints, they can just not bring any more cases, right? The problem is public defenders don't have that same ability to adjust their own caseloads for the most part with respect to their own resource constraints. And the other, you know, sort of theme or sort of model or idea that you can, I think, find in some of the discussion today is the advantage of if you can get public defenders or indigent defense players somehow to be an entrenched part of the bureaucracy, an established part of government, so that they can kind of defend their own agency and defend their own budget in a way that government agencies do, right? Once you get a government agency and government program out there, right, it really tends to be hard to kind of kill them. And if you can get more sophisticated, kind of experienced players in the process of managing to establish with legislatures the relationship to justify their own budget, right? This is sort of the part of Rich Rosen's story that I took about the North Carolina system, and I've understood that the PDS system in D.C. works something like that. They've got a really good board and a really just an effective long-term relationship with their funding source, right? So if you can ever get that kind of system where they're an entrenched part of the bureaucracy, and maybe a sort of farther fetched analogy would be the military justice system, right, where the same JAG Corps employs the defenders and the prosecutors, right, and they're on the same military pay grade, right, they're in the same military rank system, right, they're just part of the system, right, and the whole JAG system, the military justice system, rises and falls in the budget together. The federal defenders, I gather, are linked to AUSA salaries, right, and so that's another example. And then you can look abroad, right, the UK system, the national statute that governs legal services there, including public defense, is less amenable to political volatility, I guess. You know, part of the challenge in kind of getting any of that going, right, is in part a problem of federalism, right, which is just that most of criminal justice is in the states. Anytime you get some reform, right, you got to do it 50 times. There's 50 different systems you got to work through. The school funding litigation is maybe some model for how you can kind of get some unity in the strategy to approach those jurisdictions and that problem nationally, right? It's just a challenge when you can't, for the most part, kind of win in one legislature and then establish your system. So you can make your own judgment about whether to be despairing at the prospects of those sorts of remedies, right? It's kind of structuring indigent defense as part of the bureaucracy that could then defend itself, or getting legislatures to commit to some budget relationship of indigent defense and other parts of the system, or the idea of making these litigation strategies more successful. Today, I'm more optimistic because I've listened to you all and to our speakers, and so I've got this sort of Reverend Bright, Ted Kennedy, the dream will never die kind of feeling going. But I didn't come here with that. I'm not sure I'll have that tomorrow morning. So, so I leave it all to you to carry the work on and let the cause endure and let the dream never die. Thanks.
So I guess I'm the final presenter of the day, and I'd like to take this opportunity to just reiterate thanks to the Dean, the Law Review, and Rod for having us all out. It's been a great conference. Let me apologize at the outset. This is my PowerPoint here. You know, computers are marvelous, but they can't remind you to put the thumb drive in your briefcase before you head to the airport. So I'm going to be talking about this statue a little bit later. Earlier, Sean referenced someone wearing brown shoes below a tuxedo, and I'm that person. Earlier, you heard the Right Reverend speak to litigation in Florida, and Steve Hanlon as well. And so that's actually what I'm going to address today. It's the so-called excessive caseload litigation in the Public Defender's Office in Miami-Dade, Florida, PD 11. There are 20 judicial circuits in Florida, and there's a PD in each office. And so I'm going to tell the story about Florida, the home of Clarence Gideon, and it's a story that's still evolving today. This litigation is in the courts, and as I'll describe later, there are essentially two cases that are working their way up through the courts, or so it would seem. And so there are two themes, what I'd like to discuss today. Number one, separation of powers, in my papers and the binders on the back of the binder, and some reference there to separation of powers as a tool to force institutional change and improve indigent defense. And here what I'm talking about is separation of powers as an accountability enforcing measure. And I'm going to be talking a little bit about the pretty interesting and quite significant case law that's come out of the Florida Supreme Court, kind of pivoting on the notion of inherent authority, which Steve Hanlon talked about earlier in his remarks. The second theme is conflicts. And it's conflicts in two forms, really. One, in a smaller sense, and it definitely turns on this statute up here, conflicts of interest with respect to public defenders and their clients, whether they be prospective clients or current clients. And the second conflict is something that was alluded to earlier as well, the conflict between the judiciary and the legislative branches. Steve Hanlon used, I think, the nice phrase of preserving the capital. And that's what we're talking about here, I think. I think that's going to go a long way towards explaining what's going on in Florida in terms of the fits and the starts of the litigation in Florida, the excessive caseload in southern Florida. So a little bit about Florida, as you know, 1963, Gideon. And from the outset, the public defender offices were underfunded in Florida. And so it was a very kind of standard saga, and up through the decades, you'll see underfunding, quite acute underfunding in too many cases. But in Florida, this typical saga has come with a twist, because dating back to the 1970s, you see Florida Supreme Court really kind of standing up. And it's really pretty remarkable because, of course, in Gideon, there were 22 states, as noted earlier, that filed an amicus brief against Florida. And Florida was one of 5 so-called laggard southern states at that time, not extending the right to indigent felons, right to counsel indigent felons. And so, pretty remarkably, in 1990, the Florida Supreme Court states that when excessive caseload forces the public defender to choose between the rights of various indigent criminal defendants he represents, a conflict of interest is inevitably created. And 4 years later, the court pointedly declared that, quote, an inundated attorney may be only a little better than no attorney at all. That's pretty remarkable. And 30 years' time for a judicial institution to pivot like that and look at an issue in such a radically different light. And so what happens in Florida during the 1990s, there's lots of case law, and perhaps a culminating event is in 1998, where the Florida Supreme Court recognizes that it really doesn't have the power of the purse, but it urges the committee, the legislature, to appoint a special committee to look at this issue and try to formulate some long-term systemic solution to the chronic problem of indigent defense underfunding. And so the legislature's response was quick. Essentially, it spearheaded a constitutional amendment in the state of Florida, which did 2 things. Number one, it shifted payments for indigent defense from counties to the states because the counties were tired of essentially paying for a conflict counsel. And the second thing it did, remarkably, it basically expressly embedded in the Florida Constitution that the judiciary shall have no power to, quote-unquote, fix appropriations, which, of course, states a truism. And the Florida Supreme Court was well aware of that. But even more interestingly, in the immediate wake of that constitutional amendment, in 2004, the legislature enacted this provision right here. And in pertinent part, it states that in no case shall the court approve of withdrawal by the public defender based solely upon inadequacy of funding or excessive caseload. Pretty brazen effort by the legislature to tie the hands of the judiciary with respect to a pretty core aspect of its mission, one might think. Well, interestingly, so this was adopted in 2004. A lull ensues. 2006, the ABA opinion comes out, 06441, which essentially recognizes, in fact, citing some of the Florida Supreme Court precedent, saying that excessive caseload can create problems for counsel with respect to competence and diligent representation. 2006, a lull still. So 2008, the public defenders step up and they start to challenge this statute. And this was a case that Norm was involved in, two cases really. So the first case essentially tries to avoid the statute. It's an effort to decline cases prospectively and try to avoid the withdrawal language of the statute. And because of excessive caseload and inadequate funding. Well, relief is granted with respect to third-degree felonies, which essentially amounted to 60% of the PD's caseload at that time. So this goes up to the 3rd District Court of Appeals, which has jurisdiction over PD 11 in South Florida. And the court holds that you can't have an en masse kind of blanket declination. You need individualized proof of prejudice. And furthermore, the court says that the effort to decline cases is really an inappropriate attempt to circumvent the statute. And which is interesting, of course, because, obviously, plain meaning, withdrawal, decline, those are not the same things. And as a matter of fact, the Florida Supreme Court over the years is at pains to emphasize the difference between declinations and withdrawals, and in fact has expressly advocated that attorneys decline cases as opposed to withdraw from cases. So this is the 3rd District Court of Appeals, and essentially tacitly endorses the statute. Okay, so July 2009, the parties filed briefs before the Florida Supreme Court, jurisdiction briefs, and to this day, the Florida Supreme Court has not decided whether to grant jurisdiction and hear this case. It's a discretionary appeal, and essentially it's sitting there. Okay, while it's sitting there, PDs in southern Florida decide to file another case. This case directly challenges the statute, asks for a judicial declaration of the unconstitutionality of Florida Statute 27.53031D, seeks a withdrawal in an individual case. And this is the individual case of Mr. Bowens, who's facing a life sentence because of a felony enhancement. And his individual public defender is a long-time, highly respected public defender in the office, Jay Kolsky, who in 2008-2009 handled over 700 cases, which is an excess caseload by several orders of magnitude relative to national guidelines and expectations. And so, interestingly, the trial court, this is Judge Thornton in this second case, grants relief. And it's interesting, he focuses on the term solely in the statute. And by his lights, the term solely means that, in fact, you could seek to withdraw on the basis of inadequacy of funding or excessive caseload if you show something else. And he reasons that that something else is prejudice. Prejudice here. And so in this second case here, in the first case, essentially the PD was trying to seek declination with respect to, and the conflict was current clients and prospective clients. The second case attacks withdrawal, and it's looking at one individual client. And the contention is that Mr. Kolsky is not able to provide effective assistance to counsel to Mr. Bowens. And so the trial court's reaction, again, is to sidestep the statute. And to say, the statute is, perhaps problematic, if not for the insertion of this term solely. And so we're able to avoid finding the statute to be unconstitutional. So where's that case? That case has been argued. It's before the 3rd District Court of Appeal. It was argued in December. No decision has been rendered to date. So we have these two cases that are being litigated in southern Florida. One is essentially stuck before the Florida Supreme Court since July 2009, waiting for the very threshold question of whether jurisdiction is proper. And the second relates to Mr. Bowen's case, an individual effort to withdraw from a case. And again, that's been argued before the 3rd District Court of Appeals, and it's expected that there will be an opinion at some point. And so when you talk to counsel, this case is being litigated pro bono basis by the Miami offices of Hogan and Hartson. And you talk to trial counsel, and they're just completely at a loss as to why the Florida Supreme Court has not addressed this issue, because it obviously is of such profound public importance. And so, what's up with this? Well, number one, with respect to separation of powers here, a very strong argument can be made that this is unduly hindering the judiciary with respect to its inherent power. And the judiciary, of course, has institutional oversight over the bar, including public defenders who actually in Florida are constitutional officers. And number two, to ensure the Sixth Amendment rights of individuals are being satisfied in the cases before the trial court. Now, in the past, as I said earlier, the Florida courts, most notably the Florida Supreme Court, have not flinched in the face of the consequences of making a decision here. But this is a different era. This is an era in which the state of Florida is facing extreme budget crises. It's also an era in which, obviously, public defense is not held in very high esteem. You can find newspaper articles with legislators, not even disguising their disdain for public defenders. And you also see, obviously, courts not being a very high priority either. So it doesn't take a cynic at this point in time to look at this litigation and the current state of affairs and say, in fact, the judiciary is a little bit concerned. It's gun-shy, which is really very problematic. And perhaps we're at a point, as Steve Hanlon said earlier, is that really it's probably wise of the judiciary to try to preserve some of its capital. But you have to ask yourself, at what cost? And that cost is the Sixth Amendment rights of individual criminal defendants in South Florida. And, it's interesting. Over the years, in the 1990s, the Florida Supreme Court has made quite clear that it possesses the nuclear option. The nuclear option is to cut these guys loose. Cut these guys loose. And the question, of course, is number one, is whether the Florida judicial system is going to step up and say that this is an unconstitutional statute for, I think, what are very compelling reasons. And number two, if they're freed of the limitations imposed by this unconstitutional statute, to essentially make determinations here about conflicts of interest. And there's a very strong record being made below with respect that there are conflicts of interest here. And you cut them loose. And of course, Floridians, faced with that prospect, are not going to like that. Legislators won't like that. But again, who has the power of the purse? Of course, it's the legislature. And so time will tell about how this case will be resolved in the Florida courts. And it will be resolved eventually. But as I think, we know these days in terms of the public choice literature that amply, supports the view that indigent defendants are really kind of last in line. There's not much hope. So I'm going to end on a pessimistic note, notwithstanding Daryl's earlier optimistic note. I think that this statute probably will remain intact, and there may be some sidestepping. Perhaps this kind of focusing on terms solely in the statute might be a basis for relief in individual cases, or perhaps even groups of cases. But time will tell. Thank you very much.
Good afternoon. I'm the guy here who really feels out of place. I am the token prosecutor. I'm actually happy to be here, mainly because we had, as you know, 30 inches of snow in Washington. And you don't have here. And Rod actually called me in the middle of that snowstorm. They asked me if I'd comment. At the time, Missouri seemed like Florida. So I said, sure. I am happy to be here. I think this is a much needed conference. I'll tell you what I'm disappointed at. I'm disappointed that we're having it in front of this group. Not a knock on the group, but this is, we're not convincing anybody here. You know that we need this relief. You know that. These aren't the people you need to convince. You need to convince the people who are going to sit out here and hiss and boo. Nothing comes easy in this country. Absolutely nothing. I'm a guy who's always railed. I was a law professor across the border, as you heard, but I railed against the quote strict constructionists of the Constitution, because I'll tell you, if we were strict constructionists, the women in this audience would not be here. Trust me. You wouldn't vote. You don't count. You didn't count when they ratified this. I would be a much shorter man because they only counted black men at a fraction. And if we don't look at the document as something that changes, then we fail, I think, as a country. We have to look at it as a document that changes. We change. Technology changes us. It's always amazing. I can sit in my class when I was teaching, and I can mention a case, and I do what I always do. I go, the case was, and somebody, instant information, just like that. Google will give you a site. Professor Howard, that was U.S. versus so-and-so. And we have got to be able to adopt. And we have got to be able to adopt as this country changes. Now, I absolutely understand when people sit here and talk to me about innocence. I do. It's and you may lose sleep at night. But I'm going to tell you something. There is nothing like being a prosecutor. It is, and I'm going to tell you, don't get me wrong, I love the Public Defender Service. I really did. I love them. And when you can see, if you just look at the roster here, you look at Norm, you look at Steve, you look at Rich, the Public Defender Service was unbelievable. You would get your head smacked around every day. But you want to know something? You knew it was coming. For those of you who play sports, it's like walking into the court against, I was going to say Carolina, but that was Kansas! The #1 team in the country, by the way. And you better bring your A game. And you knew that. And it's not a knock against Norm, it's not a knock against Steve, but the PDS today is just as good. It's who they attract. And what that meant to me as a prosecutor is, I knew that if I were going to get a conviction, I only had to do it once. because the people next to me were the epitome of the Sixth Amendment. They were effective, and that's exactly what you want. And I'm going to tell you something, and if you have the wrong person there, you don't want to convict them. Now, I'm going to tell you, I come to prosecution from just a little different angle than most. I've always, as a matter of fact, I didn't dress this guy down, but I wish he had been in my office because I would have fired him. But while I was U.S. attorney. But I'm talking to a young prosecutor. I'll tell you, he's in the Eastern District of Virginia, and I'll also tell you the hiring they did under the Bush administration. And I'll go on record as saying this: I didn't like it at all. Just didn't like the way they handled it. But this young man says to a group of associates that is over there and trying to learn the system and things like that. He says, I can never defend anybody. I just want to put people in jail. It is the absolute wrong attitude. And to tell you the truth, the people who should be the U.S. attorney, they are the folks from PDS. And you may not understand it, but to do the job, you have to understand who's sitting at the table next to you. You have to be able to put your your feet in the defendant's shoes. You have to be able to do that. And the reason I say I come at it a little differently, I'm 58 years old. I grew up in Petersburg, Virginia. But my mother grew up in a farm town in the northern neck of Virginia. If you look at the state of Virginia, it's got two necks coming up, and those are the Appomattox and James River running up through it, and then you've got the Chesapeake Bay. And between the Delmarva Peninsula and right next to the bay is what they call the northern neck. And my mother grew up there as a farm town. And just to show you what it was in her day, she was born in 1923, and she recently passed away. I mean, the best woman on earth as far as I was concerned. But she was educated by her mother at home because the state of Virginia did not provide public schools for African American kids until they got to middle school. And I would go up there for my summers. And I'm going to tell you something. When you're a kid both my parents were college professors, so I grew up on a college campus. I was a little pampered kid, And you get up there, you're in the farm, you have to go to an outhouse. It was hard. It really was. But I sat around and I would listen to my relatives talk about people being lynched. And it was talked about as if it were like, okay, it's what happened. And for a young black kid growing up in that neighborhood, and at that time, when you hear that, and you're sitting in a country that calls itself the United States of America, it makes you sick. And then when I hear the imagery today from Steve Bright, talking about walking up and seeing the young black men chained together and looking like a slave ship, this country really hasn't changed. And what I found out when I was in law school, I wasn't going to do this. I was going to go to New York. I was going to be a securities lawyer. I was going to wear suits all day. I was going to have a good old time. Then I met my wife. And decided to do something else. She didn't want to go to New York. But, and I started, and when I was trying to figure out what I wanted to do, what's interesting about being in the public defender service is that you do lack control, and that's what I heard here. You do lack control. And the term I heard growing up was being the man. And I decided, well, Jesus Christ, why can't I be the man? And I decided I was going to go be the man. And I became a prosecutor because, and the reason I say, a guy like Rod or a guy like Norm or any of Bob, anybody should be the U.S. attorney. Because when the people are guilty, I'm going to tell you, nobody wants them in their neighborhood. You don't. If you're a rapist, if you're a pedophile, I don't care what you think about them. You don't want them in your neighborhood. The innocent are easy. They're very easy. How we measure ourselves as a society, how we measure ourselves as a civilization, is how we treat the dregs. How you treat the bottom of society. Keep in mind, I was a big supporter of Eric Holder when he said, let's have the Gitmo cases in New York City. I was a huge supporter of it. Because the way our system works, if we're going to put these guys to death and the world is watching, you want them to know we put them to death because the evidence showed that they deserved it. And the reason you have it in New York City is because the Constitution, not because Congress, the Constitution says you're going to have it at the place where the crime was committed. Just read the damn amendments. That's what it says. And nobody wants these trials in their backyard. I understand that. Nobody wants responsibility for them. I understand that. And to tell you the truth, nobody wants to defend a terrorist. Nobody does. But you want to know something? Our system says we must. Our system says we will. And when they can't afford it, it's going to be you if you're the Public Defender Service. And you should do it. Not only should you do it, you better do it. Now, should they be paid the same? Oh, absolutely. You know, it was always funny. I would, one of the things I did while I was a U.S. attorney, the D.C. office is really interesting. It is the only, you're not American Idol, right? That's not how I'm doing. 5 out of 10, Jesus. It's the only U.S. Attorney's office. It's the only prosecutor's office that handles both federal and local cases. I met with A.J. Kramer, the head of the Federal Public Defender Service on a regular basis. I met with Ron Sullivan, who's now a professor at Harvard, who was the head of PDS, and we talked all the time. They have the same job I did, the exact same job. The reality is PDS will never get the same funding that a U.S. Attorney's Office gets. Because even with the caseload, you've got to remember that we do manage a budget. But you know, if we filed in the 2 cases, I'm going to say somewhere about 18,000 cases. And those were the ones that were filed. And those are the ones that come to, and a hefty percentage of that goes to PDS. But keep in mind, that's probably 5% of all the cases we end up investigating. And that's why the federal system is always going to get the FBI, and PDS won't. And that is why the state side is always going to get MPD. And they won't. But you need investigators. Because the things that you can do from PDS, sometimes we can't do as law enforcement. Witnesses will come talk to you, and they won't come talk to the cops. And I'll tell you, I say the same thing about those who support the First Amendment. And that's why I always support the reporters. Because, you know, I think one of the things we need to do, and one of the things we should do, is approach these problems, I mean, you know, not the way the system sets it up. I mean, there's nothing in the Constitution that says we have to be adversarial. It's the way it works. Yeah, I want this guy in jail, and yeah, you want him out. But sometimes what you need to do is sit down and say, we've got a problem. How do we solve it? Sometimes those problems are easy. And one of the things you're seeing now across the country, they have it in D.C. and we were trying to make it work, is drug court. I mean, at a certain point, I actually agree with Dean Schmoke at Howard University. I mean, drugs end up at some problem not being a criminal problem, they are a health problem. When you see these people, they are sick. They have got to get some sort of help that they're never going to get in jail. And it's hard to say, let's do this with, say, a rapist. But you want to know something? I don't know that. It's hard to, but it's maybe easier to say with somebody who has, you know, a problem with burglaries. You know, sometimes what you need to do is we need to walk out of our offices, maybe as a group, and walk into the communities and say to them, what do you want us to do with this? Now, it's harder for the Public Defender Service because they do have a client. It's easier for the U.S. Attorney's Office because we have a client, but it ends up being the public. And at a certain point, when we're not getting feedback from the public, we're just simply not doing our job. But when we're talking about what the public wants and how that fits in with what a client for PDS wants, The only way you can work that is if if the two collaborate, and then what you do is you start taking large chunks of cases out of the system so you can turn limited resources into the things that really need turning to. Because when you've killed, say, 12 or 14 or 15 people, when you're a mother who's wiped out a family, public wants you to turn your attention to it, and we want them to have good health. Because quite frankly, if you're going to put somebody to death, you need to, the way the system sets up is you get a committee together. That's what the federal system requires. You have them talk to you, and then you don't sleep for 3 days as you're trying to decide whether you're going to put a cocktail in somebody's arm. But there are times when you see somebody who has, dropped a rock on some young lady's head, you'll go, okay, I don't like it, but for him I will. But you convince me, PDS, that I'm wrong. And maybe I won't. If you can't do your job, that doesn't happen. That doesn't happen. Problem solving, I think, having people sit down, talking, trying to figure out ways to reduce caseloads so that limited budgets that, granted, prosecutors can more easily handle, that PDS really doesn't have the opportunity to handle, can really pull things out. I wish I had some little flourish to end with. But I just want to say one thing. For those of you who are planning to go into either being a prosecutor or a public defender, I applaud you. It is something that is just desperately needed in this country. If you are, going to communities where you're uncomfortable, I think one of the biggest problems that we have is that we go into places where we're comfortable. You need to go into places where you're uncomfortable. You need to, we just don't have enough diversity in these ranks. And it's funny, I will just end with the Duke Lacrosse folks for a reason. It's not a public defender case. But, you got to keep in mind that we need a system that people perceive as fair. It may never be fair, but they have to perceive it. And when you listen to what happens with the Duke Lacrosse case and how it comes up and how awful we think it is, keep in mind, those young boys are treated the way, quite frankly, African Americans are treated, Hispanic immigrants are treated every day in this country. Because you know what happened to those kids? I'll guarantee you, most of you thought they did something wrong. You remember the kid who kind of spattered off about, we're going to take these black guys and rip their, you remember that there was a phone call? Some of you, because they're jocks, you thought they were bad kids. And I'm going to tell you something. It's every day in this country. Young African Americans, young Hispanic, anybody who looks like an immigrant walks into a court, and the first thing they think is, I'm going to get screwed. I don't care what happens first. They think they're going to get screwed. And it changes when you see a little more variety around the well of the courtroom. We don't see enough of it now. I appreciate it.
This is when I turn to Rod and say, what did I ever do to you to deserve to be the last speaker in this long, wonderful program that we've put together? Although I shared Bob's dream of fairness and equality and all of that as I was growing up, unlike Bob, I didn't start at the Public Defender Service. I actually went to a large corporate firm in D.C. that at the time was called Wilmer, Cutler, and Pickering. And I remember my very first day in that job, and I hated it. I think I was there 10 minutes, and I found myself saying, I have made a terrible mistake. This is not how I want to spend my time. And I don't think I ever told the people at Wilmer that I called up the Public Defender Service that very day and asked them to reopen my application because I really, really needed to be there. And I was fortunate enough that 11 months later they called me up and offered me a job. And I still remember, again, to this day, walking in the first day at PDS, and we had a training program that we all started. And we always started at the first Monday of October, sort of a reflection on the Supreme Court or whatever it was. And I remember walking into this conference room in our old building in D.C., and the carpet was old and bedraggled, and it was hot still, and the windows were painted shut. And I look around, and I sit there for 5 minutes, and I found myself saying, I can't believe they're paying me to do this. And I tell my students that story when they come and ask me, advice about where to go and what jobs to take. And the bottom line is, you better feel that way about your job. Because if you don't feel that way, look for something else. And I'm not telling you it's not hard being a public defender. You all know it's hard. And it's one of the most difficult jobs that I think anyone can have. But it's almost as difficult as being the last speaker and which is a part of the program. I'm supposed to tell you what all the answers are based upon all the wonderful presentations you heard here today. And I will tell you that the only real answer I can give you about what we need to do here is, I think it's perfectly clear from everything I've heard here today that there are no easy answers or solutions to the problem of lack of funding for indigent defense systems. And I think we all know that, and I think Norm has known that for a very long time. Which is another very good point, Rich. I'm not going to repeat for you a lot of the themes you've heard here. I mean, I think you've heard a number of them over and over again. Bottom line, ultimately, the solution, I think, to the problems of funding and indigent defense and resources, it's going to have to be a political solution. It's going to have to be people saying, we will pay for this. And the people ultimately who have to make that decision are going to be the legislators. And quite frankly, that scares me a lot. I look at some of the legislators who have no clue how the criminal justice system is supposed to work. They want to streamline habeas so we can kill people faster. We want to get rid of providing post-conviction relief for people because Lord knows that slows down justice. And they're wrong. And they need to learn that. And actually, there is no one better suited to educate the people who need to be educated than those who do this kind of work. But it's hard. You have enough on your plate already. And now we're saying to you, you have to go out there and you have to educate people. You've got to educate the media about what's going on. You've got to educate the judges. You've got to educate the legislators. And ultimately, you've got to educate the voters. Because they're the ones that everyone's looking to when they're trying to decide what they can and cannot do. And the way you do that, I think, is what you've seen demonstrated here today, which is you have to do it through stories. We can get up and we can talk about numbers and statistics and percentages and all of those good things and caseloads and all of that. But what makes it meaningful to people are the stories. It's the individual human beings. It's what Mosty's talking about when Bob. I knew him as Mosty. He was my supervisor. And so I still call him Mosty to this day. But it was what he was talking about when he was saying that they're a human being. You get to know them as a human being. And until we can communicate to the people who need to understand this, that they are human beings. Some of them are innocent. And you know what? That discussion of innocence has really started changing sort of how we talk about the criminal justice system. I remember before there was DNA. And we kept saying innocent people are being convicted, but nobody would believe us. And then along came DNA. And the irony of DNA was that originally it was used to convict our clients, in part because we had no clue how to deal with it. Because, we all went to law school because we didn't like chemistry and science and those kind of things. And I still remember to this day, Barry Scheck and Peter Neufeld and a group of people put together a conference in D.C. I think there were 1,000 lawyers who must have been in that conference room trying to figure out how you deal with DNA evidence against you. And I had handouts like this. That was before computers and thumb drives and those things. And they were there because they wanted to learn how do you deal with this. And then Barry and Peter and these guys said, wait a minute, there's another way of looking at this. Not only will it convict our clients, it can exonerate our clients. And all of a sudden, they started showing that people who'd been convicted, everyone's convinced they were guilty, were not guilty. And the DNA is what made the difference. I just gave my students in my criminal procedure class a case called State v. Youngblood, and then Youngblood versus Arizona to read. And some of you, I hope, are familiar with it. And the state case is basically saying, when they didn't preserve this evidence, they could have been tested, he was denied due process, and so it should be conviction reversed, and he should be released. And then it goes up to the U.S. Supreme Court, and they say, oh, no, you have to show, the defendant has to show bad faith on the part of the police in not preserving this evidence. And after all, look at all this evidence, he's so guilty. And then the next thing I give them is the New York Times article that talks about how years later DNA exonerated Larry Youngblood. And the whole idea is they were so sure. And they came up with this ridiculous standard, which is still the law in federal courts. Thank God, not in all of our state courts, but a lot of them. And the man was innocent. He was totally innocent. And he spent 17 years in prison for something he didn't do. And that's what started people talking. And that changed the discussion. Because otherwise everyone thought, if you weren't in the system, and a lot of people were, that all these people were guilty. And we don't make mistakes. Well, we talked today about we do make mistakes, and we make a lot of them. And what scares me is that there are a whole bunch of cases where there is no DNA. And we can't prove they're innocent. And they probably, some of them are. And a lot of them probably are. And so when Mosty says, you know, tell the stories, put the stories of the innocents out there, the problem is, and Steve cites to Richard Posner, who talks about innocence as though, well, that's easy to figure out. You know, we know those who are innocent. And as Mosty says, the reality is we don't. A lot of times we have no real way of knowing whether someone is truly innocent or not. And that's harder to say. That's harder to say to a legislator or to a voter or whatever, you know. They just didn't have enough evidence to prove him guilty beyond a reasonable doubt, because that's what you're really saying. And yet those cases should scare us too. But I think Mosty's right, and Richard's right. Put the exoneree in the front row. And put them where they're going to have some impact, and maybe then in the process we can educate people to help protect everybody else, including those who are truly guilty. And we all know there are some of those too, quite a few sometimes. We had a case in New Mexico, actually, years ago. It was a death penalty case. Thank God we repealed the death penalty last year. But it was a death penalty case, and they put 5 members of a motorcycle gang on death row. And they were sitting there waiting for their execution dates when someone else came forward to a police department somewhere in the South Carolina, and he found God. And he came forward to confess that he was the murderer and not those innocent motorcycle gang members who were on death row in New Mexico. But they looked into it and they said, no, people have been convicted. You know, so go away. And eventually I don't remember the details, but he got a bus or whatever and comes back to New Mexico, and he's hooked up with a lawyer at the time named Charles Daniels. And Charles represented him and got, basically, I once said to Charlie, what if he had changed his mind about coming forward? What would you have done? And he said, thank God he didn't. And he worked a deal, he came forward, the 5 motorcyclists were exonerated. And I will tell you, there is something very powerful about a meeting or a school class session at the law school where, and in those days, one of them would come and be there and be able to say, I was on death row and I was not guilty. Charles Daniels is about to become Chief Justice of our New Mexico Supreme Court next month. So if you want a place to move to, you may want to think about New Mexico. But those are the stories that make a difference. You know, we've talked about separation of powers. We've talked about what are the solutions to this. I'm glad to know that's not my score either. But anyway, and you know, Wayne talks about the cases in Florida where they're trying to do systemic change and sometimes individual cases. The bottom line is we all have to be bringing these individual cases or systemic cases if we have the opportunity to try to change how all of this is done. We can't just let it keep happening the way it is and the caseloads to be so overwhelming. When I worked with Rod on the Terry Nichols case in Oklahoma, we encountered a funding issue. About 2 years into our representation of Terry, the public defender for Oklahoma City announced to us that, contrary to what he had told us previously, that we really had 2-year contracts, that we were only going to be paid for 2 years, but we had to continue to represent Terry for however long it took, at our own cost. Because they had not expected it to take more than 2 years to get Terry on death row. It ultimately took 4 years to even get to trial. And I don't know about you all, but I am not independently wealthy. I mean, I had taken a leave without pay from New Mexico to go to Oklahoma to work on this case, and he talked me into it.
I'm a very good advocate.
Yes, he is. He really is. And we were looking at each other going, what can we do? And we filed a motion arguing they should dismiss the case if they're not going to pay for adequate representation for Cherry. At a minimum, they should take the death penalty off the table. To us, that was a victory, because the only purpose for that prosecution was to kill Terry Nichols. He already had life in prison without parole, and all of his pleas and post-conviction remedies were exhausted. So the only thing they wanted was the death penalty. And so our suggestion that perhaps the court should not let them seek that was vigorously resisted. We filed writs in the Oklahoma Supreme Court because the Oklahoma Supreme Court had authority over the court fund. So this was a place where separation of powers wasn't as clear as where the legislature does all the appropriating and the courts don't have the money, they just have supervisory authority. Here, the Oklahoma Supreme Court had authority over the court fund. And we filed a writ, and we said, you know, you can dismiss the death penalty, you can dismiss the case, you can order dismissal of the death penalty, or you can pay us. You know? We prefer you dismiss it. We would be happy with that. We would like to go home. And the Oklahoma Supreme Court, to my surprise, said, pay them. And they sent it back, and the judge said, well, I'll get around to it in a few years. So we did 3 writs. I became the writ queen of Oklahoma. We did 3 writs to the Oklahoma Supreme Court, and ultimately they said, pay him and pay him now. And we never had a voucher cut after that. And so I've dealt with some of these issues, at least in that context, that I had never encountered at PBS. We had another case in New Mexico, a case called State versus Young, which I think is another good example of what lawyers who are willing to put themselves out there and willing to fight and willing to make the record can do. It was a death penalty case involving a prison guard at the Santa Rosa prison, a well-loved guard. Everyone adored this man, and he was killed by a group of inmates. And they were prosecuting the inmates seeking the death penalty. And in New Mexico, the legislature has to appropriate. So we have the whole separation of powers problem. And the public defender didn't have enough money, and so the attorneys came in and said, we can't do this, much like we did in Nichols. And the New Mexico Supreme Court basically said, well, let's just stay things for a little while and let the legislature come up with, see what they're going to do. So the legislature at the next session came up with $800,000 for experts, investigators, mitigation, and all of that, and about $100,000 for this whole group of attorneys, because there were multiple co-defendants. They said, we still can't do it for what you've given us. And they litigated, and they made the record. And it goes back up to the New Mexico Supreme Court, and this was before Justice Daniels was on the court. And that court said, you can't proceed with the death penalty as long as you're not paying them adequately to provide adequate representation. And that case, ultimately, the legislature never did come up with more money to pay for it. And the prosecution realized they had better just deal that case. And so they took death off the table and worked out a plea bargain. So it was pressure that was brought to bear that ended up in a resolution of that case, which was in the client's interest. It was pressure they tried to put on the legislature. It got some money, but not enough. But the bottom line to me is you have to do that. You have to file these kinds of pleadings with the courts. You have to try to fight because you can't keep going on with overwhelming caseloads, no resources, and in some cases, from what I'm hearing, not the support of your supervisors. Bottom line is, criminal defense, as I said, is really hard work. And it's hard work when you've got the resources, when you've got an adequate salary to keep going, when you've got a supervisory group of lawyers who are there and back you up and support you. I cannot even begin to imagine how hard it is when you're in an office with an overwhelming caseload, no resources, or supervisors also who may not back you up when you need them there. And I salute each and every one of you who are doing that kind of work. And if there's one thing I think to take from this today, is that we don't have magical answers, but you don't stand alone as you're out there having those fights and digging in the front line and fighting in the trenches. And there are people in this country who will be there for you to try to help if they can. And I hope today at least continues the discussion and gets people thinking about those issues. And now I'm going to sit down and turn it over to Ron.
I'm glad that Barb ended on a little bit of a high note after the pessimism on that side of the table. The reality is we all, unfortunately, don't live in New Mexico. And I think when we have those tough separation of powers issues, we do have to have judges who respect the Constitution, who are willing to stand up to a legislature, if the legislature is not going to provide adequate funding. And I think at the end of the day, we wish that we have more judges like the judges in New Mexico are willing to say that they will take steps like taking death off the table, because that'll make all the difference in the world. Adele.
I was just going to say, one of the things we were talking about making change is getting the local bar involved, getting support from the local bar association. We also talked a lot about getting the journalism people involved and getting the stories out there, getting some public interest in the work and in the stories. And I think in Missouri there's some really great journalism schools. Right?
You betcha. We're #1 in the country.
And there's a lot of kids who are interested in these issues who could write really good stories and get the public interested in some of the issues. But I also, when I was doing some research, I came across an article that said that the bar, which is the Missouri Bar Association, that their criminal law committee, the Missouri Bar has a criminal law committee, which is co-chaired by a prosecutor and a public defender. They're planning a criminal justice symposium, okay, in April, coming up, where defenders and prosecutors can peacefully, it says here. I don't know why it has to be so peaceful. Okay, maybe it should be peaceful, but it would be a forum for people to go to bring these issues and discuss this. Because so the Bar Association is having this meeting. I just thought I would mention that in case anybody here wanted to go or planned to go and make a presentation.
I'll make a point on that because Dean Decim and I invited the Missouri Bar to hold a conference here on Thursday afternoon. Before this conference, we invited the legislator, particularly the legislative leaders, the state bar, the prosecutors, the Missouri Supreme Court. We thought it would be an excellent opportunity for them to come to be part of this discussion. And the prosecutors said, no, this is about public defenders. We aren't going to get a fair shake, so we're not going to come. So they didn't want to hold that symposium now. I'm delighted that they are going to hold the symposium.
So you'll bring the symposium to them.
Well, if I'm invited, I'll certainly show up, and I know a number of other people will as well. But yeah, we need to have, this conversation has got to be a systemic conversation. It's got to include all the actors. And somebody mentioned, why aren't there other people in the audience? Roscoe did. Roscoe, we invited him. We wanted him here. You're absolutely right. There are lots of other people than the people in this room who need to hear this message, but you got to get them to come to the table, and that's hard.
There's a lot of talk about different ways to reform indigent defense, and one of the things that's been said is that there is no single answer, and I think that's clear. In our report for the National Right to Counsel Committee, Justice Denied, we tried to isolate factors that were at play in jurisdictions that achieved reform. Clearly, the use of the media is very important. Steve stepped out, as he knows so well. In Georgia, even though things are dismal today, I don't think ever would have happened without the Atlanta Journal-Constitution and one particular reporter down there. And we've seen that in other jurisdictions as well. In addition, there are some jurisdictions, and I haven't heard any mention of it here in Missouri, where there have been citizen groups that have been involved. There was one in Virginia. I don't think it's ever gotten really fully where they wanted. There was a citizen group, and it still exists in Louisiana, that played some role in new legislation that was enacted in Louisiana within the last couple of years. Also, a citizen group is very active in Michigan right now, campaign for justice.
I think they got a whole lot of groups. I mean, it's sort
Yeah.
of
Well, have meetings that generate publicity. It's terribly important in that effort. I think the use of wrongful convictions and the innocent is powerful. In my life as a lawyer, that is the major thing that has changed. Since the first DNA case in 1989, I mean, it changes the whole dialogue, the whole discussion in profound ways. It provides a very powerful argument. And I don't think you ever remove litigation as a possibility. I heard what I said this morning. I think it ought to be used and used extensively as a pressure point. And there are different ways to go at it. And also, if you look around the country, I think the involvement of the bar is so indispensable, and you made the point, Rod, as did others. And if you look at the history of the public defender movement in this country, time after time what has happened in so many jurisdictions is that the involvement of the private bar has become negligible. And when it has existed, it hasn't been supervised, it hasn't been monitored, it hasn't matched experience with the level of cases, and that's been an enormous problem. And if you look back at the standards of the American Bar Association, which I put under my pillow every night, if you look at the standards on providing defense services, one of the things that we said and wrote about is that there needs to be the active and substantial involvement of the private bar. If you look at successful public defense programs, and there are some, the active involvement of the private bar is indispensable. But it just can't be lawyers taking cases for bottom dollar without oversight. They are the safety valve. I mean, that has been a secret to PDS. The PDS statute says the public defender service shall not take more than 60% of the cases. In truth, we've never come close to 60% of the cases, and they don't do it today. And the private bar is what makes it work, in a sense, but the private bar in D.C. is not nearly as well monitored and overseen as it should be. Massachusetts, in my judgment, probably does the best job in the country. Oscar, you mentioned Massachusetts, I think, or somebody you did, because you hadn't heard mention of it. The truth of the matter is Massachusetts is very well funded, and the caseloads of the defenders in Massachusetts are very similar to PDS. But I just kind of wanted to pull those thoughts together.
I just want to make one quick comment about litigating and losing, because Daryl and Mike both sort of have this sort of we litigate, we lose sort of pessimism, right? A couple of comments about that. One is that it is, yes, and it is the ideal place to bring in the participation of the private bar, representing us, representing public defenders in their quest, so that you're not having to represent you and your client at the same time. The second thing is that it causes the prosecutors to go, damn, they're not going away, right? I mean, I might litigate 100 times and lose, but I'm a criminal defense lawyer. I lose, right? I'm practiced at that. We are. We're very good at it. But the notion that, okay, they told me I lost this time, I'm going to attack it this way. They told me I lost that time, I'm going to attack it this way. We are limited only by our creativity, and so I think there's really cause for optimism there. And the third part of that is the media and journalism and the right to talk about that. We lost all those cases that got overturned on DNA. They were losers, right? And all of the, Gideon and his progeny, those were losers, right? That's how they got up there to the Supreme Court. So I take a lot of heart out of losing, because I, again, have so much practice with it. But those are the cases we can sell in the media, we can sell later, and we can bring in the private bar to help us with.
David.
We're talking about sort of making these changes and systemic changes and stories. The question I have is, in effect, the stories of innocence become exceptions to the rule, right? People say that's the exception, not the rule. And the people who need to change, the voters, people who went through the system, those people are silenced already. They have no representation, right? I mean, to be honest, people really don't care about the poor and the minorities who are going through the criminal justice system, right? And so these folks are disenfranchised already. We already talk about collateral consequences, and that's still not deemed to be punishment. We take away the right to vote. We don't give them housing. We don't give them education. And that's not problematic on the back end of getting out. for people who are guilty. And so how do you envision folks in middle America or other places saying, listen, yeah, we really care about this 12.5% of African Americans or this growing population of Hispanics who are poor, who don't have a voice anyway. They don't vote for us, so why change the system to make it fair and equitable for them when they really have no real stake?
I don't know the answer to why, and I think that's a point I was trying to make, but I didn't. But you know, it's where the system has to be. I mean, it's easy, as you say, David. I think you're absolutely right. The ones that are innocent they are very compelling. They will bring tears to your eyes, but they're easy to handle. I mean, it's the folks that are at the bottom of the barrel. That's where you measure yourself. It's no different than, it's easy to talk to an adult. It's tough to talk to a kid. You got to, to talk to a child, you've got to stoop down. And to handle somebody who's got big problems, and quite frankly, I mean, when I look at things coming out of Gitmo, and when I look at 9/11, let's just assume that one of those planes misses and we end up with some of these terrorists. I mean, these guys are going to be hated. They've got to be represented. And we measure ourselves as people by how we're going to treat them. And at some point, we've got to, there've got to be leaders in this country, and I'm hoping that they're here. I'm hoping that they're somewhere that start teaching people that we don't treat women the way we treat them. And we integrate our schools because that's the way it's supposed to be. And when we talking about the criminal justice system and we're talking about equal justice, it's for everybody. I don't care how bad you are, I don't care how good you are, but when you come into your system, you're going to be treated fairly. And I don't know how to do it. I don't know how to do it, but it's like all great concepts. I mean, you've got the founding fathers sitting up in Philadelphia in the middle of the summer trying to write this stuff down, and I will guarantee you this. I mean, Norm and I weren't there, but
Norm was there.
I can tell you, I just had to do that because. But I'll guarantee you, when they were writing that, what they're thinking about, that's for us. That's for us. It is, and we can talk about we the people and all the people, and somehow we've got to bring the words back when we're talking about we and us. And I think one of the reasons you have a problem with the legislatures is because when they look at the folks, and everybody sort of said, they don't see themselves. They don't see their kids. And you look at these jails exploding. I mean, you would think that we are the nastiest country on earth when you think about how many jails we built and how many people we put in there. But you know what always strikes me when I walk in? I don't care where I walk into a jail. I can walk into a jail in Kansas. I can walk into a jail in this state. I can walk into a jail in New Mexico. And I know it happens in D.C. And I will guarantee you that 80, 90% of the people in there will be minorities. And for me, that's my family. And you can't convince me that they're the only people in this country breaking laws. You can't convince me of that. And what happens is we simply have to change the way we do things, and it's going to be, it's just got to be a process. We have to start with the folks who are going to be in law school and are going to walk out. They're going to be the governors of these states. They're going to be the legislature, and you start the education process right here and right now. Is there a fix-all? No. You got to change attitudes. But I'll tell you, I mean, it's who becomes a cop. It's who becomes a prosecutor. And I think that folks who are thinking about defense attorneys, you ought to become a prosecutor. And guys who think about being a prosecutor, go become a defense attorney. But somehow we've got to change the system, and the system's run by people, and that means we have to change people. I don't know how to do it, but when the innocent are easy. And I forgot who brought it up. I think Rich did. Bring them down to the legislature, but you've got to be able to put them in a position where they're thinking that could be me, where that could be me, because as soon as you start making it personal, I think things are changing. It's easy for me because when I was a kid, I'm going to tell you, it was me. It was. When I'm sitting around there talking about my uncle getting lynched, you're sitting there going, oh. And it's got to be the system where anybody sitting in this room, can, and you'll say, how many of you are related to somebody who spent time in prison? And you see more than just hands that are of color going up.
Does it count with your husband?
Adele, you're getting to the too much information portion of the talk. I don't know how to do it. I don't know how to do it, but I think that as people, you got to. I mean, this is a country we haven't treated people well. Folks with disabilities, we just haven't treated them well. But slowly but surely, it's taken 200 years, but it's turning, and it may take another 200 years. But that doesn't mean you don't do it. You got to keep at it.
I was just going to say, I think empathy is very important. I think innocence is important. But, look at the death penalty context. How far was the dial moved on that one? You still got Tim McVeigh, who admitted guilt ultimately, correct, right? Mm-hmm. And so, to me, the only thing that moves the dial is money. You finally, undid the Rockefeller drug laws in New York. Why? Money. It's the fisc, right? So the argument needs to be made, you're going to save money on the front end by adequately funding these folks on the appeal, correct? And of course, kind of a cognate argument is innocence, of course, but it's all about the money. That's the only thing that moves people at this point. And long-term hope would be empathy, absolutely, or wrapping ourselves in the Sixth Amendment. But that only goes so far, in terms of the public debate.
I never mentioned money because I don't believe if you do it right, I can prove that it would be cheaper. As much as I would like to associate myself with that position.
So you don't believe it, so you won't say it?
Yeah, it's a little thing I have.
Kat?
I just want to say, in terms of how you change that conversation, one of the things that I've seen with the time that I've been dealing with media and legislature and trying to change that conversation, is I think the pendulum is beginning to swing just a little, but it is a one-by-one education. When you really sit down with people and you explain to them the 3 pages worth of collateral consequences that are going to attach to this minor conviction, their eyes go, what? There is not an awareness. I don't think if you did the man on the street interviews, anybody out there would have a clue what the sentences are, what the collateral consequences are, just how off-kilter our corrections and sentencing policies have become. And I think that's part of our task, is going out to those community groups, going into schools, going to, the churches, wherever it may be, we can get a platform to really begin to educate people that we're doing things like in St. Louis, a felony jury trial, and somebody who was charged with putting a nickel slot in a quarter slot machine as a felony. I mean, that kind of stuff is crazy. And when you explain that to people, that's really what we're talking about, I think people are beginning to move off that, throw everybody away and lock up, lock them up and throw away the key, whatever that is.
Well, and money does matter in death penalty cases, because if we can get the conversation about death penalty, that is such a distorting effect on the overall quality of justice in the system, and it's so expensive, and we use so many resources there. And you point to a state like Wisconsin or any of the non-death penalty states. Those are most of the states where they have a much better functioning criminal justice system, and it's because we aren't pouring so much money into the art of trying to kill somebody.
I agree with that.
And that's the debate we have to begin to take on. And people say, we can't talk about it. We have to, just like decriminalization. Those are the things that do matter in terms of where money does matter.